Good afternoon, everyone. My name is Ravid, and I'm the managing partner of Ravid Law Group. I'm here today to discuss landlord-tenant issues in the world of COVID-19, everything you need to know today until tomorrow. We have a lot of issues to discuss, so let's just jump right into things. Before we get started, what I want to explain is that I'm not going to try today to convince you that the landlord's position is the right one or the tenant's position is the right one. Instead, what my goal is to identify all of the key issues that you should be thinking about from a legal perspective and a business perspective. And in doing so, to encourage everyone to see that there is no black and white answers here. These are unprecedented times. A lot of these legal theories and business issues have not been tested, certainly not on the legal front, not in the courts. And so while some previous case laws can help shed some light as to how the courts might decide on some of these issues, it's really anybody's guess. It's at best a 50-50 proposition. And so with that in mind, from our perspective, we're strongly recommending that all of our clients, all of the landlords, all of the tenants, they all work together to try to come up with a fair and reasonable business solution. It's not going to be economically feasible for landlords to just simply terminate all of their leases and hope to recover damages. That might make sense in a few cases, but certainly not across the board. It's also not going to make a lot of sense for tenants who really need to preserve their capital to decide to start filing lawsuits against all of their landlords and to get mired into protracted litigation regarding some of these issues over a few months' rent, or maybe even 3 or 4 months, or however much time this closure continues for. So again, I want to emphasize our recommendations for the parties to work together. In that vein, one of the things that I wanted to talk about was that what we've seen are a lot of parties already coming together. That's not always going to be the case. There are there's no one size fits all. There are going to be situations where the landlords really need to dig in. Remember, there are 3 parties really involved here. You have the landlord, the tenant, and the landlord's lender. So it's really 3 parties. In an ideal world, everybody would come together and everybody would give up a third, for example. Maybe the tenant would pay a third of the rent, maybe the landlord would pay 2/3 of the mortgage, and maybe the lender would abate 1/3 of the loan payment during these temporary times. But that's not what's happening. And again, our firm is really involved in the landlord-tenant relationship, not with the lender, but we always understand that that's in the background of these negotiations. That's sometimes the driving force of these negotiations. And so also keep in mind that there's no one size fits all, in that you have some tenants that really are struggling on 2 fronts. Their business is suffering tremendously, but also they have very low cash flow, if any. And so there's a serious concern of whether or not they can even survive. You have other tenants that are, quote unquote, bigger tenants. They have the cash flow to withstand this for several months. They have strong balance sheets, but their business is obviously suffering as well. On the other side of the spectrum, you have some tenants that are doing okay, or they're not really suffering that severely. You have some that are prospering. Think of the grocery stores. And so there's really no one size fits all. Again, you can have some landlords who, for a variety of factors, really don't have much leeway, and they might need to insist that the tenant pay full rent. Maybe they'll agree to an abatement. On the other side of the spectrum, you might have some tenants who really need to dig in on their position that no rent should be due. They cannot use the space. That was what was contemplated. And they're going to take a hard line on their side. What I've seen is that's really the 2 extremes of what's been happening here. And I would say about 80%, 90% of the time, what I have seen are the parties are actually trying to work together and coming up with compromises. And I want to list out 6 different examples of compromises that we've seen at our firm over the last few weeks. We've already been working on some of these. I've probably worked on about 2 dozen of these. already, and really there's no limit to how to solve these. We're limited only by our imagination and creativity, and here are some of the ones that I really liked that came up that struck me as really good efforts by both sides in trying to come up with a fair compromise. The first one that I've seen is where the landlord and tenant agree that the tenant's rent for the months of April, May, maybe even June will be 100% fully abated. In exchange for that, what the tenant will agree to do is extend the lease term by the same amount of months that they received the rent abatement. So if the rent abatement is effective for 3 months, then that lease term will be extended for 3 months, and so that the landlord can recover this money at the end of the lease term. That's one example that I've seen that I like. The second one is where the landlords and tenants agree to split the baby right away. Tenant will pay 50% of the rent for the months of April, May, maybe even June. And in exchange, that's it basically. There's nothing else as part of that conversation. It's just a 50-50 split right away. Both sides are suffering, and that's the way to solve the problem. Some landlords in that type of negotiation will sometimes take the position of, well, it's 50% of your minimum rent, but I still have to pay property taxes, I still have to pay operating expenses, and therefore I want full reimbursement of my actual out-of-pocket expenses, and then we'll split 50-50. So I've seen the variations of that as well. A third example that I've seen is where it's somewhat counterintuitive, but it's really the landlords who are suffering from a cash flow perspective. And what they're doing is they're going back to their stronger tenants, and we've been working on some of these deals, and they're saying, okay, I'm suffering cash flow because nobody's paying me rent. I've been reading statistics where as low as 20% in a mall context, 20% of mall tenants have paid April rent, as high as maybe even 50%, but certainly not higher. Maybe some of the stronger malls are getting closer to the 50%, but with the stronger tenants are there. But it's as low as 20%, and that's not survivable, certainly not long-term. What I've seen in those cases, some of those landlords, at least some of them who suffer or who need the cash flow, will go to the stronger tenants and say, why don't you pay me 3 months rent up front, and I'll agree to abate that rent later, maybe a year from now when everything goes back to normal. There are going to be some lender issues with those types of transactions, but it's achievable. And I thought that was a pretty creative way to solve some of these issues. Another one that I've seen is where the landlords are quite strong. They have themselves strong balance sheets. They can afford to withstand this for a few months. They're telling the tenants, okay, look, I can't actually give you rent abatement for a variety of reasons, but let's put a value on what your rent was for April, May, maybe June. So let's just say your rent was $10,000 per month, and we'll multiply that by 3 months. That's $30,000. Well, I can't give you rent abatement, but what I will do is I will give you cash for that lost revenue, for that period of time when you had to pay me my rent. So for the $30,000, what they'll do is they'll give you a tenant improvement allowance, where you'll get $30,000 and you could use that money to improve the properties. That's perceived as a win-win proposition. So that's another one. And a fifth one, two more that I want to give an example of. The fifth one is where you see the landlords and the tenants agreeing that the tenant will drop down to paying percentage rent. So this is when the tenant will reopen. Some essential businesses are open, restaurants doing takeout. And instead of paying you the actual rent, they'll pay you a percentage of the sales, 5%, 6%, 7%, maybe as high as 10%. Of whatever the sales are, for example, for a period of 12 months. And again, I've seen hybrids of that where, for example, the tenant will pay 50% of the rent while they're closed, and then once they reopen, they'll pay a percentage of the rent. And then finally, and this really applies with some of our bigger national retailers and also some of the national retail landlords, where the parties have decided that, look, we're not going to talk money here. We're both able to withstand this, even though business is suffering for a couple of months, but let's not focus on a couple of months worth of rent. Let's focus on a bigger picture. The world will come back to normal at some point. And when it does, I want you, from a tenant perspective, the argument or the negotiation goes in the sense that the tenant will say to the landlord, I want you to put me in this mall that I've been wanting to get into that you've told me there's no space. It's certainly not, there's no space that I would want. And so we're anticipating there's going to be some empty spaces. You're going to have some tenants going out of business. I want you to put me in that trophy mall that I've been trying to get into. Or if I'm already in the mall, I want you to move me to that 50-yard line position that I've been pushing for. And so that's part of the discussion. On the other side of that discussion, landlords are telling the tenants, okay, I'll tell you what, I'll fully abate your rent for the 3 months. That's fine. But promise me you're going to do this deal that I've been wanting you to do in this other mall that you've been on the fence on. You've thought about going there. You haven't felt strong about it, but why don't you agree to do that deal? Again, nobody's talking about doing it tomorrow, because if you were uncertain before COVID-19, you're going to be a lot more uncertain now. But the idea is when things get back to normal, the tenant would agree to, take a chance, go out there and do that other deal. And again, this is all part of the mix. So those are 6 examples that I've seen where parties are negotiating good, fair, reasonable business solutions. Now let's jump over and talk about the legal side of things. On the legal side of things, the biggest question is rent still due? And the most relevant lease provision that parties are focusing in on is the force majeure clause. From the landlord's perspective, they want the force majeure clause to be the one and only lease section that anybody focuses on. Their position is it is the only relevant section. Everything else is not important, is not going to dictate what the final outcome should be. We start the discussion and analysis at force majeure and we end it there. And the reason why the landlords are saying that is because the way the force majeure clauses are written, they say that if X, Y, or Z occurs, then the parties are excused from performing their obligations, yes, except that the tenant is still obligated to pay rent. So if you, tenant, are prevented from operating because of COVID-19, we understand we're not going to default you for failing to operate, but you cannot use COVID-19 force majeure to justify not paying rent, because we've already contemplated that this might happen. We might have some force beyond control occur where we've agreed that even if that does happen, you, tenant, will still pay me rent. The other side of that is tenants will say, well, A, we don't think the force majeure clause applies, and I'll explain the reasons why the tenant will take that position. Or B, there may not even be a force majeure clause in the lease. And C, even if it does apply, the tenants will say that, well, they have other remedies that they can look to, other lease provisions that are helpful, number one. And 2, they have common law defenses, which we'll talk about. And 3, there's also in California civil code statutes that that the tenants can use to help their position that rent is not due under the circumstances. So the first part of the analysis is, does force majeure apply? The first issue is, when you do this analysis, is to look at the language of the lease and the force majeure provision and find out, is pandemic covered under the force majeure clause? Meaning, does it say that if a pandemic occurs, then all obligations are excused except for tenant's obligation to pay rent? Now, our firm, we've looked at over 500 lease forms for of our clients in the last month or so. And out of those 500 lease forms, we only found 2 lease forms that used pandemic to describe as a possible force majeure event. A lot of them will say, if there's a hurricane or an earthquake, some kind of weather-related event, or if there's a war, or if there's a riot, in those situations, then the parties are excused except for rent. But they don't say that if there's a pandemic or a disease outbreak. And so I would say for the most part, almost all parts, pandemic is not going to be the basis for a party to use force majeure. But I'll put an asterisk on that. There is this catch-all language, which we'll talk about in a second, which might bring in pandemic into the discussion. The second example of how a landlord would try to apply force majeure is to say that this is an act of God. This pandemic that's taken over not only our California, but the entire country and the entire world, it's an act of God. we looked at a lot of case law throughout the country, obviously within California as well, and we couldn't find a consistent theme of whether or not this current situation would be obviously considered an act of God. There are some case law that suggests that disease outbreak would be considered an act of God, other cases where it doesn't. So I think it's too difficult to be able to predict with any certainty of whether or not this would be described as an act of God, but it's another way that a landlord would argue that it should be. The third example is probably the biggest one, certainly during the closure period. We are talking about eventually lifting these closures relatively soon, but certainly during the times of closures, landlords are going to easily be able to invoke the government restriction as a reason why force majeure is applied. So a lot of these force majeure clauses will say earthquake, tornado, floods, etc., or a government order or a government restriction that delays or prevents parties from performing. Well, obviously we have the stay-at-home orders all throughout the country, most of the country, and if it's not at a state level, it's at a local level. And in those cases, then the landlord will say, that's pretty black and white. We have a government order that says you cannot perform. That is the reason you are not performing. And because that's the reason you're not performing, the force majeure clause says, yes, that's okay. You don't have to operate, but you still have to pay me rent. And so that's a big one, probably one of the biggest ones that's going to be invoked by the landlords. The next one is a lot of these force majeure clauses will have language that will identify a list of categories. Again, we've talked about them: natural disasters, earthquake, floods, etc., wars, riots, etc. And then it'll have this catch-all language that will say, or any other cause beyond the party's reasonable control. If it's any other cause beyond the party's reasonable control, then that's also a force majeure event that qualifies, that triggers this provision. Sometimes it will say any other event, or sometimes it will say any other similar event. We've analyzed case law throughout the country, and it's not consistent, similar to acts of God. It's not consistent. The courts have not ruled on this consistently. I would say most courts will narrowly construe this clause to say that only if the other listed examples are similar to the current situation, a virus outbreak, a pandemic, then in that case, then the catch-all language will be used to cover the current situation. But there are courts that will say a flood is not like a pandemic. A hurricane is not like a pandemic. A war is not like a pandemic. And therefore, that was not what was contemplated by the parties when they agreed that the tenant would still pay rent if they were delayed or excused from performance. In fact, the courts would say, well, you're not even excused from performance because force majeure doesn't even apply in that case. So the tenants would have to look for other ways to justify not performing. One way is to say, well, I'm going to comply with laws. But again, in that case, it's a flow chart. You have to constantly check all the boxes. The government restriction would then possibly apply if that's a force majeure clause. So anyway, so the catch-all, just to kind of conclude on that issue, would help to bring it in if the previously listed examples would cover disease or outbreak, and it may not be applicable if those previously listed examples of force majeure clauses are not similar to it. But even when they're not similar to it, there are some courts that will rule that the catch-all language should be a way to incorporate pandemics into a force majeure clause, and therefore, again, from a landlord perspective, they think that it should be applicable, and therefore the tenant's rent's not due. One final issue on whether or not the force majeure clause applies is that a lot of them are written in a way that says that one party has to provide notice to the other. The party invoking force majeure needs to notify the other side that we are using force majeure clause, and here is notice. The idea behind that is under normal circumstances, landlords and tenants don't want the other side to game this provision and to basically take advantage of it by saying, yeah, I was delayed in finishing up my construction of your space, but the reason that I was delayed was 6 months ago I incurred a force majeure event because there was some flood or something else. So parties are concerned about those types of situations. So a lot of times the force majeure clause will say, you have to give me notice so that I can actually go and check to verify that force majeure is in fact a justifiable excuse for your performance. But I wonder how strictly courts will enforce that. I mean, the normal circumstances is where you're not aware of possible force majeure events. Here, everybody in the country is aware of this pandemic. So I wonder if notice is going to be strictly required. So now that we've talked about whether or not the force majeure clause will apply, now the question is, from the tenant perspective is, well, A, what if it doesn't apply? And I gave some examples why it wouldn't apply. Or B, what if the force majeure clause is not contained in the lease? What if the lease is silent? And believe it or not, there are a bunch of leases out there that don't have force majeure clauses. Again, when we reviewed the hundreds of leases that we did, we found that about 5% of leases did not have a force majeure clause. Interestingly enough, in California, a very widely used lease form is the AIR lease form. It's not used as often in retail, but that lease form does not have a force majeure clause. And so those are the types of leases where tenants will try to then pivot and argue that, hey, I am excused from performing not only all of my normal obligations, but also my obligation to pay rent based on two sets of arguments. One, there's a statute in California that I can invoke, and two, the common law defenses. The common law defenses we're going to talk about in a second more thoroughly. We'll cover more thoroughly, but the common law defenses are the doctrine of impossibility and frustration of purpose. We're going to get into that as we talk about this, the California statute, which is California Civil Code Section 1511. And California Civil Code Section 1511 is really a hybrid of doctrine of impossibility and force majeure in essence. Let's take a look at what the language says, and then I want to talk about some of it. Some of the language here is pretty strong language that a tenant can really use to support their position. The rent is not. Okay, so Civil Code Section 1511 says, and I've highlighted and underlined the key words, the performance of an obligation is excused by the following causes. I'm going to skip over number one. I'm going to just jump to number two first. So performance of an obligation is excused by the following causes. When it is prevented or delayed by an irresistible, superhuman cause or by the act of public enemies of the state or the U.S., comma, and here's the key part of number two, unless the parties have expressly agreed to the contrary. So this reads like a force majeure clause if there's some superhuman cause, or there's a war, or any irresistible force, then the party is excused from performing. And if you notice here in this civil code section, it does not say that everything is excused except for rent. Rent is still due. This clause does not say that rent is still due. And so the question are all of the tenant's obligations excused? Well, this section number 2 says that if the parties have not agreed otherwise in the contract, if there's no force majeure clause in the contract, then the parties can be excused if you can fall into one of these categories that is described here. Is there an irresistible superhuman cause here? And if the lease is silent, then maybe you can say I'm fully excused. If the lease is not silent, then you lose the benefit of this section 2. So again, the key is the lease silent on this issue? But a bigger issue is if you look at number 1, which reads a lot more like the doctrine of impossibility. Here it says the performance of an obligation is excused by the following causes when such performance or offer is prevented or delayed by the operation of law. And here is the key part, even though there may have been a stipulation that this shall not be an excuse. So here, it's very interesting. It says that if the reason why you're unable to perform is due to an operation of law, a government order that says you cannot operate, then you are fully excused from performing, even if the contract says otherwise. So even if you have a force majeure that says you still have to pay me rent, even if you are still required to perform, if there's a government order that says you cannot perform, then this seems to say that the tenant can take the position that they're not obligated to perform any of their obligations, including the obligation to pay rent. This is pretty powerful language. Now, nothing is 100%. We've looked at case law and we couldn't find anything that discussed this Civil Code Section 1511 in a way that would really be applicable to the current circumstances. We're going to talk about some case laws in a minute. So I'm not very confident that this will be enforced the way that I'm discussing it right now. That's number one. Number two, the landlord also has an additional argument to negate the effect of this statute by saying, well, wait a second, what performance are we talking about here? Well, okay, if my lease said that you still have to operate even though there's a legal order saying that you're not supposed to operate, then I agree with you. Then that provision that would still force you to operate in my lease, then yes, then it's invalid. But what performance are you looking to be, what performances are you prevented or being delayed from that you're trying to claim, tenant? The obligation to pay rent, there's nothing in the government orders that say that you are prevented or delayed from paying me rent. You can still pay me rent. In fact, a lot of the government moratorium orders, and we'll talk about that later, actually say rent is still due. And so landlords will try to interpret this language quite literally and say, look, performance of paying me rent should not be excused. You're not prevented or delayed as a result of these orders from paying me rent. So again, it'll be interesting to see how the courts will analyze that provision. So let's talk about the doctrine of impossibility. They all kind of mesh together. The doctrine of impossibility is defined as something is, I'm going to paraphrase this, something is essentially impossible if it's not practicable. It's considered to be impracticable when it can only be done at an excessive and unreasonable cost. And then it says a little bit later on, it doesn't mean literal impossibility. Again, it emphasizes it has to be so that if the performance would require excessive and unreasonable expense. So keep in mind, for example, you have these government orders that say that all non-essential businesses must close, but we allow essential businesses, which include, for example, restaurants, to continue to operate by offering takeout order. Well, offering takeout orders is really not viable for a lot of restaurants. We represent a big restaurant chain, and they've actually told us that they tried to do the takeout. And what they discovered was that the revenues that they were generating for their takeout, again, it wasn't a big part of their business before COVID-19. What they discovered was the revenues that were generating were not enough to pay down the utilities that they were incurring from operations. So it just was, I think that's a very good example of where something can be done, but it can only be done at an excessive and an unreasonable cost. And therefore, in that sense, it would be impossible to perform the contract. Another example, another defense is the frustration of purpose, where the tenant would argue that, look, the whole reason that we entered into this agreement has been frustrated by a supervening circumstance that was not anticipated, such that the value of the performance of the party is substantially destroyed. The argument really focuses on several things. One is the reason for the contract. What was the primary purpose of the contract? It was, from a restaurant perspective, to allow people to come into the restaurant, sit down, order wine, alcohol, order food, come every hour or so, and have, generate substantial revenues on a daily basis. Well, they cannot do that right now. And so the purpose of the contract has been frustrated. Think about an apparel retailer. They can't operate at all. I mean, maybe there could be some sales online that take place, but what is happening at the store level? Nobody can come into the store. They only signed the contract because they were expecting that guests will come into the store, touch and feel the product, try it on, and then just, everybody's talking about the experiential part of retail. Well, that is not possible right now, and that purpose has been frustrated. So tenants will be able to argue that their performance has either been rendered impossible. Again, it doesn't have to be literally impossible, but impracticable. And also the purpose of their contract has been frustrated. Let's talk about some cases that have applied these common law defenses. When I say common law, what I mean is that these defenses are not written into the contract. These are defenses that are available to you outside of the contract. So some of the cases that we've seen, everybody's been talking about, two of the law school type cases that really were used to describe these situations. I think they're pretty interesting to talk about, especially the first one, which I like the symmetry of discussing the coronation cases. I like the concept of coronavirus, named after the crown, and also coronation cases for the crown. So the coronation cases go back to English law, where there was a person who rented an apartment to view the coronation of King Edward VII. The tenant told their landlord, I'm going to rent the space so I can actually see the coronation. And it turned out that the king became ill and the coronation was canceled. And so in that case, the parties agreed, or the courts agreed, that there was a frustration of purpose. The purpose of the contract was to go and be able to view the coronation, and that was canceled, and therefore it rendered the whole contract invalid in essence. Or at least it excused the party's obligation to perform, which included the obligation to pay the rent. Another example, more on the impossibility side, is when an opera singer is hired to perform at an opera house, and the opera house burns down. Again, they cannot perform because there's no, the opera house is no longer there. Those are, going back quite a ways. But let's talk about some California cases. There is a California case, and by the way, there are cases throughout the country, and they all. It's similar to a lot of the issues that I talked about before. There is no consistent theme as far as how these will be applied. There's no consistent theme of whether or not they will be applied when there's a force majeure clause, or if they will be applied, if there's a force majeure clause, some jurisdictions will take the position that, well, we're not going to look at these defenses because the parties already anticipated that this might happen, and they already bargained for how this would play out in those circumstances. Other jurisdictions will say, no, we're still going to look at these defenses, and they might still be applicable even though there's a force majeure clause. And I gave an example in California how even if there's a force majeure clause that says operation of law might not excuse performance, the civil code statute says otherwise. A case that we looked at in California that seemed interesting was where a tenant signed a lease to sell alcohol. And then after they signed the lease, by the way, said that the tenant can only sell alcohol, can use the space to sell alcohol, and cannot use the space for any other use or purpose. Well, after the tenant signed the lease, then prohibition laws were passed and now prevented the tenant from being able to sell alcohol. And the court ruled that, yes, the tenant signed the lease that said they could only use the space for selling alcohol, and they no longer can do that, and therefore their obligation to perform is now excused. Interestingly, I read a case that had similar fact pattern in another state where that lease actually said that the tenant can use the space to sell alcohol or any other or use the space for any other purpose, any other legal purpose. And that court said, no, we're going to still enforce that contract because, yes, you don't have to sell alcohol, but that contract contemplated that you're going to use it either for sale of alcohol or for any other purpose. And so therefore, you still have the ability to use the space for other purposes. And therefore, we're going to still enforce that contract. So again, it kind of shows, yes, there's a distinction there. By the way, we can distinction the opera house, the coronation cases. Those were one-time events. The opera house, not even a lease. The coronation case, well, there's somewhat of an apartment. It's English law. And so, again, there are ways to distinguish all of these cases depending on which side you're on. There's really no certainty as to how a court will apply these defenses or statute to the current circumstances. Again, I want to emphasize, for all of those reasons of uncertainty, that's why the parties would be best suited for striking a deal. But if the parties need to, analyze their legal rights, the next issue to look at is outside of force majeure and those common law defenses is the parties should be looking at other lease provisions. The first one to look at is, does your lease give you a rent abatement clause? And there are some stronger tenants who are able to negotiate for some of these clauses in their leases, which say that if the landlord takes any action which would deprive the tenant of their use, access, or in retail visibility of their space, then the tenant is excused from paying rent. The key there is that it says that usually, first of all, not always, again, you have to look at the language. There are some leases that don't require the landlord action to be the purpose, the triggering event for why the tenant is deprived of their use or access. But most of these clauses will say that for a tenant to invoke the rent abatement clause, you have to show that the landlord took the action. So that's really going to be relevant mostly in a circumstance where a landlord close down a mall, for example, when there is no government order that requires the landlord to close down the mall. So the landlord is just doing it on its own. and maybe without justification. Maybe again, the landlord could try to claim other force majeure reasons why they're closing down the mall, but to the extent that they are not, to the extent that they're violating their lease obligation to allow you access or use of your space or visibility, then the tenant might be able to claim rent abatement. Same concept with service interruption. A lot of leases will say that if a landlord fails to provide utilities to the space, then at some point the tenant has the right to abate rent. But again, the landlord is the one who has to take the action, or in most cases, not always. There are leases that are written more broadly to the extent that the tenant is simply deprived of their utilities or other services, then they have the right to abate rent whether or not the landlord caused it. So again, you want to look at the lease language. The next one is a very big one, co-tenancy. Co-tenancy is going to not only play into what should occur during the time of closure, but it's definitely going to play in even after we start to see people reopening their stores on the retail side and reopening of the malls. So there's a lot to discuss with co-tenancy. Let me take a step back. Co-tenancy typically will say that if the mall, for example, has, let's just say we have 100 retailers. If fewer than 80% of the retailers are open and operating, so if you only have 75% of the retailers open and operating, then there's what's considered a co-tenancy violation. And if there's a co-tenancy violation, then the tenant can either have full rent abatement, or maybe pay 50% of the rent, or maybe they drop down to percentage rent. So if there's a violation, the tenant gets some kind of rent relief. And they also say that if any of the anchors go dark, or maybe they'll say if 2 anchors go dark. And when I talk about anchors, we're talking about the department stores. You hear, Nordstrom closed, Neiman Marcus. There's talk that they're going to go bankrupt. If those anchors close, just that alone, one anchor, for example, goes dark in some of these co-tenancy clauses, that in and of itself would trigger a violation and give the tenant some form of rent relief. So tenants are really going to be focusing in on co-tenancy clauses and trying to use those clauses to justify why they either don't owe any rent, or maybe they only owe some partial rent. So let's talk about, does the co-tenancy clause qualify? Does it apply? So first thing you look at, some of these provisions will say, well, in order for the tenant to have the benefits of the co-tenancy remedies, the tenant cannot be in default. Well, did you pay April rent? If you didn't pay April rent, maybe you're in default. Again, the tenant will argue, well, I'm not in default because I never owed rent because doctrine of possibility. And again, who knows, you go down that rabbit hole. But assuming for a second that those defenses are not available to you as a tenant, and assuming that rent is due, if you're trying to invoke co-tenancy, can you do it if you haven't paid rent? Maybe not, probably not. Second one is, a lot of these clauses will require the tenant to stay open in order to take advantage of the rent relief. And so, are you dark? If you are not operating, then the question is, can you still invoke the co-tenancy clause? And then even if you are operating, what if you're only operating for a few hours when the mall requires you to be operating for 10 hours? Or what if you're only operating for takeout instead of having a sit-down restaurant? Are you fully open? Again, those are issues that are going to have to be flushed out in the courts to the extent that parties can't come up with an agreement. The next one is what happens, what are these remedies? Again, I mentioned that some of them will say the rent is fully abated. Some will say that maybe you drop down to 50%, but some of them will say that the tenant is obligated to pay percentage rent. What happens in those circumstances? Well, if you have to pay percentage rent, there is case law. Well, from a tenant's perspective, that would be fantastic. Oh, I'll pay you percentage rent. Well, guess what? I'm closed, so I owe you 0 rent. Well, there is case law out there that basically says that if a lease is purely tied to percentage rent, then there's an implied covenant that you have to stay open and operate. And so again, that will be interesting. Well, can you invoke the percentage rent clause where you only have to pay a percentage of your sales if you're not operating? What if you're prevented from operating? How can you take advantage of the percentage rent clause? Again, those are issues that are yet to be determined. Another one is that you have to provide notice to the landlord if there's a co-tenancy violation in some cases. So again, tenants, be mindful that if you're going to try to take advantage of the co-tenancy clause, you might need to send a notice to your landlord. A lot of this will be relevant not so much during the time of closures, but mostly during the times of reopening. Some of these clauses will also allow the landlord to have a cure period. So they'll say, well, before you can actually take advantage of a rent break, this violation has to be taking place for 3 months or 6 months or even a year. By the way, co-tenancy clauses sometimes will say that after, if there's a year of co-tenancy violation, then at some point, or maybe 2 years or whatever it is, the tenant actually has a right to even terminate the lease. So landlords are going to be scrambling to make sure that they get out of this co-tenancy violation ASAP. But again, they'll first say that the co-tenancy doesn't even apply because of you haven't jumped through all of these hoops. The last one is really one where landlords once again are going to try to invoke the force majeure clause. The co-tenancy clauses are somewhat written in a way that says that you don't get the benefit if there's a force majeure event. The next issue is also an interesting one, which is the condemnation. And there are leases out there that will say that, I would say almost all leases will say that if the property that you're leasing is condemned by the government, then several things can happen. Number one, they'll say oftentimes, not always, that your rent is fully abated. Number two, they will say, again, not always, but sometimes, or I would say most of the time. Two, they will say that to the extent your property is condemned, then the lease will get terminated. We looked at, again, hundreds of leases to analyze the language, the particular language of the leases, and most of them don't talk about regulatory taking. Most of them focus on physical taking. The government comes in and actually takes and uses your property. So you hear about governments taking over some hotels. They're actually using your space to house, people who are homeless or things like that. That's actually the government taking your space. Not that that's happening through condemnation. That's usually, from what I've read earlier reports, that's happening through cooperation between the owner. They're gladly able to give up the property that's otherwise unused in exchange for money. So that's happening. But in some cases, again, the government are talking about actually physically taking over property. If the government actually takes over the property, that's when the lease clauses, that's how the lease clauses are typically drafted, to talk about whether or not there was a taking. But they don't oftentimes talk about temporary taking. Usually it's whether or not there was a taking that occurred, and that's it. So regular taking, temporary taking, not always covered. But let's just assume for a second that it is covered. Well, is the government order that says that you cannot use your space, is that considered a taking? Well, there's two conflicting concepts. One is a government that is coming in and taking your property, or two, is the government exercising their police powers, in which case it wouldn't be considered a taking, which wouldn't trigger the condemnation provision. Are you deprived of all of your benefit of the premises? Again, in some cases, not all benefits. And then also in California, sometimes when you cover the condemnation in the lease, there might be additional statutory rights that a tenant will have, but a lot of times the leases will say, good California leases will say that here are the rights and remedies that you may have. You might have, under some circumstances, the right to avoid rent, or you might even have a right to terminate. But unless we covered the circumstance in this lease, you, tenant, agree to waive all of your other statutory rights that you might otherwise have for claiming any kind of relief due to condemnation. So it'll be interesting to see. It seems like a bit of a stretch to me, but again, these are unprecedented times. It'll be interesting to see how the courts interpret those clauses. The next one is, it's kind of similar to the first one with the rent abatement clause. A lot of leases, even if you don't have a rent abatement clause, will have a section that basically says that the landlord can make whatever changes they want to their property. Again, stronger tenants are able to revise those provisions to say that, well, you can make whatever changes you want so long as they don't materially and adversely impact my use or access or even visibility to my space. So again, has the landlord overreached here? Has the landlord exceeded what the government restrictions require, or what is deemed reasonably necessary? And if that has occurred, then maybe the tenant can argue that that is reason for rent abatement, or at least a claim that the landlord is in breach. Other relevant clauses, again, we talked a little bit before about notice. You have to notify the landlord. But again, should you be required to provide notice? There's issues with notice. Do you need to strictly comply with the way the notice provision is written? Notice sections will often say that you have to provide notice based on, in a way that is sending out a Federal Express notice, by Federal Express, or personal delivery. And what if you're just emailing now? Everybody's out of their offices. And so again, you have to be careful, depending on what rights you're trying to preserve, you might want to follow the lease requirements strictly. One thing that comes to mind is an exercise of an option. For example, in California, it's a strict compliance state. If you deliver notice one way, but the lease requires you to deliver it another way, you might lose your option, even though you've done everything else correctly. Other sections, just going back for a second, you have casualty. Some people are trying to claim that maybe casualty, this is a casualty and therefore they're excused from rent. We'll see again, I think that's a stretch. Also compliance with laws sections, which say, well, if I'm not invoking force majeure for my reason for not operating, I'm saying that I'm basically complying with law, and that's why I'm not operating. And then the final thing before we switch to another subject is a tenant may be able to argue a breach of quiet enjoyment, but again, I think in those situations, you have to show that the landlord is the party that has caused you to be interfered with. And a lot of leases will also include restrictions. Even if that does happen, do you still have the right to terminate the lease, or do you still have the right to claim rent abatement? A lot of leases will say you can't, but instead you can only sue for damages. And so it'll be interesting to see if that gets triggered. I'm sure everything will get triggered. It'll be interesting to see how the courts interpret those situations. The next issue I want to talk about is the construction delays. A lot of leases, before they start, the landlord has to do landlord work to the space. Sometimes it's just pure as is. I'm delivering the space exactly in the condition that it's in today. But a lot of times the landlord has to do some work. Well, because of these government orders and the pandemic, a lot of times the landlords are delayed in completing their construction. Now, construction is considered an essential business and it can continue, but it has limitations. You used to be able to have a 30-person crew on the job site, but now maybe you can only have 2 or 5 or maybe 10. So you can still do work in some jurisdictions. Some jurisdictions you can't do any work. New York enforced some strict construction restrictions. And so in any event, in some places you're either completely prevented from doing work, or you're maybe in other jurisdictions allowed to do work, but in a limited basis. And so the landlords are going to be suffering delays. And well, what happens if the landlord delays? A lot of leases for the stronger tenants will say if the landlord is delayed in delivering the space, then the tenant might be entitled to some rent credits, free rent. And on top of that, in some cases, the tenant has the right to terminate the lease. But again, a lot of those clauses are written in a way, not all, to say that the landlord is excused from that obligation to delay the space to you by certain deadlines if the reason for the delay is force majeure. So again, another example of where a landlord will be claiming force majeure. Some leases, again, for some stronger tenants, will say that, well, fine, you can claim force majeure for a delay that would otherwise give me a right to collect rent abatement. But my lease specifically says, and we've negotiated a bunch of these leases where it says, well, landlord, you cannot claim force majeure to justify a delay beyond 3 months, 6 months. And if the delay is for that long, then I can still terminate the lease, even if force majeure caused a delay. So landlords have to be mindful of that and be careful on that. Also, if there is a force majeure delay, sometimes the leases will say that, yes, you can claim force majeure delay, but no more than 30 days or no more than 60 days. And so you have to be mindful of that too. On the other side of the spectrum, there are tenant delays. And what if the tenant, a lot of leases will say, okay, I'm going to deliver the space to you, and tenant, you have to start paying me rent 60 days after I deliver the space to you, 90 days after I deliver the space to you, or 120 days. The idea in retail especially is that the tenant can come in there and do their build out of their store. Even in office context or warehouse, tenants have work to do. So the idea is that this free rent period is really a time for the tenant to build the space out in the way that they're going to be able to use it. And so what happens there? Well, if you have a free rent period for 90 days, then what happens if you can't do your build out because you're prevented from doing construction? Well, is the rent still going to be due 90 days later? Well, the landlord, the tenants are going to argue again that they cannot get their work done. Maybe again, they'll invoke compliance with law section. I was prevented from operating and therefore my time period should be extended. A lot of leases in the retail, again, for the stronger tenants will say that the stronger tenant, that 90-day rent clock doesn't start until the tenant gets their permit. That's referred to as permit protection. And if I can't get my permit, then my 90-day clock doesn't start. What do you do if you don't have permit protection? Can you still get an extension? Maybe. Again, what I've seen is, I would say this is I'm fairly optimistic. When it comes to construction delays, I have actually seen now this probably in about 50 leases that we've been helping our clients with. And I'm happy to say that in all cases, the landlords have agreed to work with the tenants and the tenants have agreed to work with the landlords. People recognize that the construction delays is a different issue and it can be analyzed differently than what if the tenant was already open and paying me rent. And a lot of times what I've seen the parties agree is, yes, we'll agree that we'll extend those deadlines, and landlord, you're not going to be subject to penalties. Tenant, you're not going to be required to pay me rent. We'll agree that we're going to toll that build out period until construction can resume in full force. And then we'll start to consider when rent is due. So I'm fairly optimistic that those issues, at least on a business level, seem to be getting worked out quite well. Okay, next topic is business interruption insurance. And does it apply? So I would say we are in the second round of, I guess I'll say a 10-round match. The first round of business interruption insurance, of whether or not it applies, is that the tenants were looking at their business interruption insurance. Most businesses will carry business interruption that says that if my business is interrupted, then I will be able to collect insurance, and they're paying premiums for that. And the insurance company is supposed to step in and come in and pay you for your business interruption. Well, the question is, what constitutes business interruption? And what has turned out is that a lot of these business interruption insurance policies will say that, yes, we'll cover you if X, Y, or Z occurs. Maybe if there's an earthquake, we will cover you. But we will not cover you if there is a virus outbreak. Virus outbreaks are expressly excluded from business interruption insurance policies. So the first round, a lot of businesses were reaching out to their insurance companies and saying, hey, there's been a pandemic. We need you to pay out the business interruption insurance. And the insurance companies have responded, it doesn't apply because we have this virus outbreak exclusion. And oh, by the way, the second reason is there's no physical damage to your space, which is a requirement under all situations, even regardless if there's a virus outbreak. You have to show me that there's physical damage to your space. And the question is there? So let's first discuss physical damage. There are cases, again, throughout all the jurisdictions. In some cases, I would say in many cases, you actually require physical damage to the space. And this virus, is there a physical damage? It's in the air. Even if you touch a doorknob, you can still clean it. Or is it contaminated? There are cases that talk about, well, it's in the air to such an extent that you can consider there to be physical damage. It's so ubiquitous everywhere you go. And so therefore the physical damage part arguably should be satisfied. Again, we don't know. The courts are going to have to analyze and rule on that issue, but you might not get past the first hurdle, which is that there's a virus outbreak exclusion. Well, that was the first round. The second round, now you see these lawsuits being filed on a daily basis now, and I don't know what the number is, but they're all over the country, where the businesses are saying, wait a second, insurance companies, you can't collect my premiums and now it's time to pay, and you're trying to, get out of your obligation by trying to claim these exclusions. And oh, by the way, we're not even arguing that there's a virus outbreak, although that's one of the arguments. The main argument now is, in the second round, is it's not the virus outbreak that's preventing me from operating, it's the government order. The government, the laws are preventing me from operating, and therefore your policy does not exclude that kind of coverage, and therefore you should be obligated to pay me insurance based on that. We'll see how that plays out. We're also hearing that there are state legislatures throughout the country, and now even at the federal level, where there is some representatives are working to force insurance companies to pay out business interruption insurance in this circumstance. The idea is to force insurance companies to pay out even if there's a virus outbreak, regardless of having to prove physical damage. I think, again, the notion is that there is physical damage based on a variety of reasons. Ultimately, what the goal is to make the insurance companies pay. And the real question is, A, is that enforceable? Is that constitutional to require a company who, from the insurance company perspective, hey, have a contract that specifically says, if you want this coverage, you have to pay me money. If you didn't pay me money, I can't pay you. I have no money. We're talking about trillions of dollars of losses. It's not like these insurance companies are sitting on a pot of gold and it's just a matter of just deciding whether or not to pay. My sense is if legislation passed and it was considered enforceable and all of a sudden business interruption had to pay out, these insurance companies would have to pay out all these businesses, they would go bankrupt. Without without government backing. So my suspicion is that to the extent that this plays out in a way that businesses do get to recover business interruption insurance, it's going to require government backing of that. It'll be interesting to see what happens in the future as well. We'll talk about that with business interruption. The next topic I want to talk about is the rent deferrals and forgiveness agreement. So you've heard me really focusing in on why I believe that the parties should work together to strike an agreement. And once again, I'm pleased to report that we are seeing a lot of landlords and tenants working this out on a business level. And they are striking those deals. I mentioned 6 examples of pretty interesting, creative ones. What happens if you've struck a deal, you've been able to strike a deal? The first issue is on confidentiality. A lot of landlords, rightfully so, are reaching out to their tenants saying, hey, before we start talking, putting things on paper, I want you to agree that you're going to keep our deal confidential. I don't want to give you this amazing deal and then have everybody else find out, and then everybody else is at my doorstep demanding that I give them the same deal. Likewise, tenants are concerned about confidentiality because they might agree to one bad deal with this tenant, with this landlord, because of maybe they have a bad lease, maybe they're under some bad circumstances, but they don't want that one bad deal to carry over to their deals with these other landlords, and where they might have a stronger lease or might have stronger sets of circumstances. So confidentiality is important, and parties should include that in part of their agreements. But this is a personal plea. I've seen these confidentiality agreements. In my sense, these could be 2 to 3 paragraphs. I have seen parties send 10-page agreements. I've seen parties send one-sided agreements. Now's not the time to, be sending those kind of agreements on a personal plea. Let's just kind of cut to the chase on the confidentiality. We shouldn't be spending legal fees going back and forth or wasting time going over confidentiality provisions that are written in a way that are too overbroad and one-sided. Let's just agree we'll both keep this confidential and not disclose this. And yeah, if one of us does, you could sue us for damages. I don't know how that will get enforced, but at least we'll make that commitment in the contract. Next issue is waiver. Again, I mentioned all these reasons why a tenant might claim that rent is not due. So if you are about to give the tenant some rent relief, you want to make sure that they waive their rights to then claim, well, I don't owe you rent. Yeah, so June is expired and I've gotten rent relief, but what happens in July? All of these other reasons, you don't owe me, I don't owe you any other rent, and I can come back and sue you even if I've signed this agreement. So you want the tenant to say, I'll give you this deal, but you can't sue me for anything else related to this time period based on any other type of defense or common law or statute. This one is an interesting one that I've seen that I think is important. Some of these agreements are saying that, hey, if there's going to be government money that is being issued, and we don't know, we've seen the PPP program that has some component that could be used for rent. It's questionable how it will be applied. It's mostly supposed to be for payroll. But what if a business does receive government money that is supposed to be allocated towards rent? Or what if the government passes legislation? Again, we're not done with all the legislation. What if they give money to the lenders so that they can offset mortgage payments, or they might give money directly to the landlord to offset your rent? So if whoever the money goes to, if it's supposed to be attributed to, let's just call it April or May rent, if the government says, here, we're going to actually give you the money for the next 2 months. If the landlord receives 100% of April and May rent, and the tenant already paid it, or maybe the tenant agreed to pay only 50%, well, if the landlord was made whole, then again, the tenant should be able to recover whatever the tenant paid, so that there isn't a double dipping. And likewise, from the landlord perspective, if the tenant receives 100% of whatever that rent was supposed to be, whether by way of business interruption insurance, we talked about that, or the government money, then in that case, then that money should be allocated towards these deals. It'll be interesting to see. It's going to be a little bit complicated. How do you enforce all of those things? We don't know where the legislation is going, but I suppose it doesn't do harm. I think from a fairness perspective, it makes sense. But again, the language should be written clearly to enforce those provisions. It's not, so far I've seen some language that, still needs to be ironed out. A lot of times what you'll see in these agreements is that the tenant must agree that there will not be any future defaults. So yes, I'll give you free rent for April, May, maybe even June. I'll give you 100% free rent. But tenant, if you commit a default in August, all bets are off. I get all that money back. I don't want to give you this sweetheart deal. And then the idea is you need to be a model tenant after this. You need to really be thankful for this free rent that I'm giving you. And you can't, all of a sudden stop paying me rent in the future. So I'll give you this deal now, but if you commit a default in the future, I should be able to recover my rent. Now, it's not clear that those will be enforceable in all circumstances, but that language is important to put in. My preference is to focus on, I think what's most fair is to really focus in on monetary defaults in the future. I don't think it's fair. Again, a lot of these provisions are drafted quite broadly. It doesn't strike me as fair to say that if a tenant fails to provide you with an insurance certificate 2 years from now, then that means that all of a sudden we're going to spring back to this rent abatement for 2 or 3 months and say, oh, you know what, you never gave me that insurance certificate you were supposed to give me on January 1st, 2024. Guess what? That agreement you signed said if you ever commit a default, all bets are off, I get that money back. So again, my sense is we should really be focusing on monetary defaults. The next thing to think about is the extension of term. Did you agree to paid all rent in exchange for an extension of term, how that rent will play, what that rent should be. This next one is another one where, again, I'll make my personal plea like I did with the confidentiality provision. And, some of these agreements will say that, hey, I want you to not only tell me that you've suffered financially, but I want you to give me proof. I want you to give me documentation. My sense is, can we all just take judicial notice that everybody has suffered? Let it be a self-certification where the tenant says, hey, I'm representing and warranting you that my business has suffered. Now, we know not all businesses have suffered. If Whole Foods comes to you and says, hey, I need you to give me rent relief, then yeah, fine, I agree. Landlord should then require the tenant to show proof. But if, an apparel retailer or a restaurant comes to you and says, hey, I've suffered financially, I think we can all accept that they all have suffered. Most favored nation, I'm just going to skip. But my general rule is they don't really work. There's a lot of variables to each deal, and you can't just cut and paste for every situation. Every situation is different. The last one is a very big one to think about in these agreements is the lender consent. Landlords are not in a position to just say, sure, you want free rent, go ahead. I'll give you 3 months of free rent. A lot of times the landlord's legal documents will provide that the landlord cannot give tenants free rent or modify their leases that were otherwise approved by the lender or that required approval or, whatever it is. There are restrictions from a landlord to just giving away free rent. And so a lot of these provisions will, a lot of these loan documents will restrict the landlord. On top of that, a lot of tenants will have received SNDAs from their lender, which is an agreement signed by the lender and the tenant. And in that case, the question is, what do those SNDA provisions say? And some of them will say, a lot of them will say that you tenant agree with the lender that you will not you will not enter into an amendment with your landlord that will reduce your rent, or you will agree not to pay rent in advance more than 30 days, or you will agree that you won't terminate the lease without the lender consent. So the question there is, what do? Should you sign this agreement without the lender consent? My answer is it's easy, you shouldn't. But let's be practical. If we're talking about 1 month's rent of reducing it by 50%, what's going to happen? I mean, the only time that it's really going to be relevant is if the lender ends up foreclosing on the property and becomes your new landlord. Then they'll take the position, hey, you signed that agreement without my consent, it's not enforceable. But if your landlord is not really at risk of losing the property, and you're talking about some, relatively small amount of rent relief in the grand scheme of things, maybe you don't need to push on it, but again, I would like to push for either getting the consent or at least getting a rep and warranty from the landlord that consent is not required. But let's take the reverse. What if there's a substantial rent relief? Back in the Great Recession, I helped an office operator who was leasing, a pretty substantial company, leasing millions and millions of square feet throughout the country, and they needed to get out of business, and they were paying millions of dollars to their landlords throughout the country. And in those situations, we made it an absolute requirement that we weren't going to pay millions of dollars to their landlords and run the risk that the lender could one day come back and say, well, wait a second, we never signed off on that. You still owe us all that rent that you otherwise thought you got out of in exchange for a lease termination. Okay, let's talk about eviction moratoriums. Most states have been, or many states have been passing these eviction moratoriums, which effectively say that a landlord cannot go to court. So under normal circumstances, if the tenant doesn't pay rent, the landlord will send the tenant a default notice. If the tenant doesn't pay the rent, following that notice, then the landlord has the option to terminate the lease. Once they terminate the lease, then they can start an eviction action. They would go to court, and eventually the court will issue a judgment in favor of the landlord. And then after that happens, you have a sheriff who will come out and lock the doors and basically allow the landlord to recover the space. There's a whole legal formal process to evictions. Well, a lot of states and local jurisdictions have passed moratoriums on evictions. In California, on a state level, basically saying that you cannot use the courts to actually complete the process of an eviction, of a lease termination. You can maybe send default notices, but you cannot actually kick somebody out. On a state level in California, there's no eviction moratorium for commercial properties. Instead, what Governor Newsom said was that he will permit local jurisdictions to pass their own moratoriums, eviction moratoriums. He's not going to say that those are unenforceable. So every local jurisdiction, or many local jurisdictions, have imposed or have passed their own eviction moratoriums. And on the LA County basis, I'm sorry, let me back up for a second. At a state level, even though there is no eviction moratorium, there is one, because the Judicial Council on April 6, 2020, basically issued a moratorium on all evictions in all California state courts. So this is not the governor acting, this is the Judicial Council, and they've effectively said that they will not hear any eviction action in any California state court. There are some exceptions. If you are a threat to the health and safety of others, then that would be an exception to that. But otherwise, they will not hear a UD action. They will not hear an eviction action. Now, so practically, you're not going to be able to kick somebody out right now. That's different than putting somebody in default. But let's read what the LA County eviction moratorium provides. The LA County eviction moratorium basically says that for a tenant to prevent a landlord from evicting the tenant, they must provide the landlord notice within 7 days. That's a little light, within 7 days of when the rent is due. They must notify the landlord that they're unable to pay, and for reasons due to COVID-19. The LA County version also says that, this is pretty good. By the way, the LA County passed one moratorium in March, and then in April they updated it. They made some changes to it. So the second update changes basically now gave the tenants the right to repay whatever rent they weren't paying during the emergency. They said that the tenants will have up to 12 months to repay the rent. And so, which is pretty high. It's a long time relative to some other moratoriums that we've seen. It says that you cannot impose a late fee or interest for a tenant's failure to pay rent during these times. And it also allows, as I mentioned before, self-certification, which I really like, where the tenant has the right to self-certify. So if you're in LA County, you are protected by this, but there's a big wrinkle to that. LA County says, based on this second order, that the LA County moratorium only applies to the unincorporated areas within Los Angeles County, or The incorporated areas in LA County, so the incorporated cities within LA County that have not passed their own eviction moratoriums. If the local cities, if the incorporated cities within LA County pass their own eviction moratoriums, then this eviction moratorium on the LA County basis is not effective. It's no longer, it does not control. And now you have to look at what the local cities have passed. So for example, LA City is an incorporated area within LA County, and they passed their own eviction moratorium. Therefore, the LA City moratorium trumps the LA County one, and you can't rely on the LA County one. Again, if you're leasing property, commercial property in LA City, I'm only focusing on commercial properties. So let's look at what the LA City one provides. LA City one is very interesting because it says, hey, we're going to issue this eviction moratorium. Landlords, you cannot take action against any tenant that leases commercial space here, except for 3 types of tenants. If you are a tenant that is a multinational company, or if you're a publicly traded company, or if you're a company that has 500 or more employees, then you are not protected by the eviction moratorium, and the landlord could technically go through the process. Now, I mentioned that on a state level, you have the Judicial Council, which says we're not going to hear these cases. But in LA City, at least the landlord has the right to put the tenant in default, terminate the lease if you are a major company, a public company, or have 500 employees, et cetera. So if you're one of those, then you're not protected by these different things. But in LA County, it also says you can't charge late fees or interest. In LA City, it says it like the LA County moratorium, you can't charge late fees or interest. Interestingly, the LA County one said you have 12 months to repay. The LA City one says you only have 3 months to repay if you're a commercial tenant before the landlord can put you in default. So if you are a small business, you can't have a landlord impose late fees or interest. A landlord cannot go through the eviction process. The landlord must give you at least 3 months after the emergency is lifted to repay the amounts. And if, for example, if you haven't repaid it, let's just say 6 months after the emergency is lifted, then the landlord can start evicting you and put you in default and do all those other things. Santa Monica, let's take a look at Santa Monica because I think it's pretty interesting. It's got a lot of teeth to it. It basically says that a landlord cannot endeavor to evict a tenant during this emergency status. And that includes that you cannot issue a 3-day notice to pay or quit. You cannot issue a notice of termination of the lease, which is a very important part of the eviction moratorium. It gives the tenant the right to notify the landlord in 30 days, which is pretty nice, better than the 7 days, which was in LA County. You're allowed to notify your landlord by mail or by email or text. And here's where, again, there's more teeth to it. If a landlord knows that a tenant has suffered as a result of COVID and they still try to terminate the lease, then the landlord action will be considered invalid and the tenant can sue and recover attorney's fees. On top of that, if you can show that the landlord acted in bad faith in trying to terminate the lease, then the landlord is subject to a $15,000 civil penalty. Again, no late fees or interest. And in this case, they didn't go as far as LA County, but they give the tenant up to 6 months to repay the back rent. Also, it says that if the landlord recovers government money, then for the lost rent and kind of what we talked about in the rent relief, rent abatement contracts, then the landlord can, if they recover that money from the government, then they can't double dip, they can't collect it, they have to give credit to the tenants. San Francisco has an interesting one. A lot of the same things that we talked about already. It carves out, unlike LA City, remember it carves out tenants with 500 employees or public companies. San Francisco City says that everybody's protected except if the business has generated more than $25 million in annual gross receipts. So again, they're trying to protect the small businesses, not the larger ones. Okay, let's look, and then lastly, just to come out of California, we're talking about New York. New York has issued an interesting one, which is very vague and broad. It just says that for 90 days during this emergency status, landlords do not have the right to evict any of their commercial tenants. And so again, it doesn't talk about the other steps that a landlord can take short of evicting a tenant. There are all of the bad things that a landlord can do to a tenant. There is legislation in New York that is being talked about maybe requiring that a landlord give full rent abatement to small businesses. You know, I don't know how that's going to get enforced without government backing, but again, things to be worried about from a landlord perspective. You have to be watching those government legislation. Let's talk about a very key component to this. What happens if you're subject to these moratoriums, but you as a landlord, you know, everybody looking at the landlord is, again, I mentioned the insurance company sitting on a pot of gold. The landlords are not sitting on a pot of gold. They have bills to pay. They have lenders to pay. They have a livelihood themselves. And they're suffering just as well as everyone else. What can they do if a tenant is not paying rent when they're supposed to be paying rent? Now, all of these orders, all of these moratoriums still require, they actually expressly say that the rent is still owed, it's still due. Nobody's saying that the rent is abated. So what happens if a tenant owes rent, they're subject to these moratoriums, but they're not paying? Well, the landlord can and should send default notices to their tenants. Again, you have to be careful. For example, Santa Monica, be careful not to say I'm terminating the lease. Be careful not to send a 3-day notice to pay or quit. We're talking about just putting a notice, letting the tenant know that there is a default because they haven't paid rent. Why? Because that triggers a lot of other things. It gives the landlord a lot of other potential remedies to enforce against the tenant. You may want to do that also to preserve your rights, landlord, instead of opening yourself up to arguments that there's been a waiver. Now, in some cases, the landlord may want to take that extra step, depending on their jurisdiction, to actually terminate the lease. I gave an example in LA City. You don't get this protection, the eviction moratorium protection, if you are a public company. And so if a public company is leasing space, commercial space in LA City, and they're not paying rent, well, a landlord can default you and even terminate your lease. Will they want to practically? Probably not, but they might. There are some cases where landlords really do want to recover their space. They maybe have signed a bad lease with below market rent. So be careful, tenant. Don't lose out on your good lease. Maybe if you're going to pay, then you would pay. If you want to preserve your rights as a tenant, maybe then what we've been recommending to clients is to pay under protest. Preserve your rights to claim the defenses of frustration of purpose, impossibility, etc. Again, it's not clear. How will the courts enforce that if you try to enforce it? We don't know. Maybe the courts will say, well, the spirit of these eviction moratoriums is to say that you cannot enforce a termination right, even if you are a major company or anybody else. So again, it's one of those things where we don't know how this will play out. But what can go wrong? What can go wrong if a tenant is in default, and what should a tenant be worried about? Well, you can lose a lot of different protections. You might lose the protection of an option. A lot of leases will say that if you commit a default during any time of the lease, that option that I gave you, tenant, you're going to lose it. So because the idea is an option is really one-sided for the tenant, and I'm only going to give it to you if you've been a model tenant. If you've ever committed a default, you haven't paid me rent, you're going to lose that option, even if you eventually do repay me. So again, if you're a small business that you're not obligated to repay right now, maybe you're excused, but it's not clear that all tenants will be excused. So you have to be worried about, am I a tenant that is not considered a small tenant? If I'm a public company, do I want to pay the rent because I don't want to lose my option? You might lose, if you're a restaurant, rights to a patio if you're in default. You might lose an exclusive right. Maybe you bargain for the right to sell certain products on an exclusive basis. Well, maybe those provisions will say that if you committed a default, you're no longer going to be entitled to that protection. So again, you don't want to default. There's also an interesting one, which is the rent abatement clawback. There's a lot of times, remember I mentioned earlier that there's this free, I put it in quotes because that's another hour conversation about what is free and what is really baked into the deal. But what happens if a landlord says to the tenant, I'm going to give you 90 days or 120 days to build out your space, and I'm going to abate that rent. I'm not going to consider it free rent. It's rent that's due, but I'm going to abate it. And so long as you have not committed a default during the life of the lease, you never have to repay me that rent. In New York, they love to put that into their leases. But from a tenant perspective, you want to get rid of those clauses. If you haven't, be mindful that if you commit a default in the future or even now, you might open yourself up for a landlord to claim that they can claw back that free rent that they gave you 3 years ago for your build-out period. So again, you want to be careful of those types of provisions. Again, will that get enforced? Who knows? I don't know if that would be enforceable in normal circumstances, but you never know. You also might have a loss of kickout rights. You might have a right to terminate the lease after 2 years or 3 years if your sales are down. And so you don't want to lose out on those protections as well. So you should just be mindful that if you have a right to terminate the lease after 2 or 3 years, maybe you want to make sure that you're not in default and then lose that protection. Landlords also have the ability to draw down on security deposits and letters of credits, maybe if you're in default. So again, be careful of that. You might also have a right to burn down the letter of credit if you're not in default. So again, be careful not to lose out on the potential for the burn down applicability. I do want to mention something real quick about bankruptcy issues. We've seen a few cases out there, Pier 1, and now I've heard about Forever 21, and there's a few other cases where it's interesting to see how the courts are interpreting some of these issues. In bankruptcy, and again, I'm only going to talk briefly about this. In bankruptcy, a tenant that after they file for bankruptcy, they may not owe rent that they otherwise owed before they file for bankruptcy, but if they want to stay in their premises after bankruptcy, they might, after a certain period of time, after 60 days, they have to start paying you rent. Otherwise, you know, they have to basically give up the space. Well, Pier 1 wanted to hold a going out of business sale and obviously couldn't do that during the pandemic. So the question is, should they be obligated to pay rent? And the courts agreed that they can suspend. I'm not sure how that's going to play out. Is it a deferment or an abatement? It's not clear how these will end up getting ruled upon, but I know Forever 21 is trying to do the same thing with these going out of business in the leases where they've decided to give back the space, but they're still occupying it. The question is, do they have to pay the rent on time to preserve the opportunity to have a going out of business sale at a later time? Something to keep your eye on. Okay, let's talk about the final issue here. What should you do about drafting lease clauses? Post-COVID-19, everybody's going to be expanding their force majeure clause to cover pandemics, to address whether rent is due. Some tenants are going to start to try to push back on that, but will that work is yet to be determined. You're going to want to address the construction delivery deadlines and rent commencement date, how those future pandemic, because again, we're not just talking about today's current pandemic, but there's anticipation that this is going to reoccur. Maybe if it's not COVID-19, maybe we're going to have a different virus outbreak in the future. So, you know, everybody needs to be mindful of, we're not just trying to address for today's current problem, which is something we need to address in new leases, but we also need to address for future problems. Quiet enjoyment, there's some issues we talked about there. You want to maybe update your language there to talk about making it clear that we're talking about a landlord depriving you of the right that otherwise not justified in taking. Condemnation, a landlord may want to make it clear to avoid any doubt that, hey, if this kind of thing happens and I'm required to shut down the mall, or you're prevented from operating due to a government order, that is not considered condemnation. You still have to pay me rent. Waivers, it's an interesting one. Can you waive frustration of purpose or impossibility? What we talked about in California, the civil code statutes, where it seems to say that you cannot waive certain rights there. It doesn't say you can't waive the statute, but my sense is that you probably can, as far as it relates to the impossibility portion. That's section number 1 of 1511 of the civil code. Waiver of frustration of purpose, it doesn't seem to me that you should be able to waive those defenses, but you know, I don't know. Time will tell, but it doesn't seem to me that that's possible, but certainly landlords may want to try to put that in their leases. From a tenant perspective, you may want to go back and look at those leases and say, hey, I don't want to lose out on my option. I don't want to lose out on my exclusivity. So maybe update your leases to make sure that you don't lose those benefits, those very important protections that you've negotiated for yourself merely because there's some dispute during some pandemic or any other event like this. The rent abatement provisions we talked about, again, depending on which side of the table you're on, you may want to expand that to try to say that the tenant doesn't have to pay rent if they're prevented from having use or access. Landlord's perspective, and they only want to limit that to the situations where they're the cause for the problem. Co-tenancy clauses, I have a feeling those are going to be revisited on a massive basis, because a lot of the language there is going to need to be tightened up for all the issues that we talked about earlier. Notice sections, should you be allowed to accept notice, you know, without following the strict requirement of the lease? Maybe in a pandemic emergency, maybe email should be sufficient. Even before COVID-19, we've been seeing it for the last several years where parties are agreeing that electronic notices should be sufficient. And then business interruption insurance, it'll be interesting to see how that plays out, because what landlords might try to do is enforce their tenants to now carry business interruption insurance without the viral outbreak exclusion, and to make sure that their insurance policies would cover them. The question is, can the tenants actually obtain these at a reasonable cost? Well, first of all, will they be available? If they are available, will they be available at a commercially reasonable cost? And that's yet to be determined. It's not clear that, it doesn't seem that an insurance company is going to be able to collect enough premiums without making it exorbitantly expensive to cover these kind of situations where everything hits at once. Again, we're talking about trillions of dollars of losses all at once. So that's it. Thank you everyone for joining me today, and hopefully you've been able to emphasize to you that there are a lot of legal issues to think about. There is no bright line way to analyze these issues and to feel comfortable or confident that you're going to be able to make this claim and prevail, and really want to emphasize that the parties should work together to come up with compromises. So once again, thank you everyone, and until next time.